And I start looking at this one section in particular, and it's the same initials, an R, 6 days in a row. And I thought, maybe the guy worked 6 days in a row, but maybe he didn't. Let's request his timesheets and see if he actually worked all those days. And sure enough, the 2 days that our little boy was in the pool, this guy was off. And even though he'd initialed the pool chemical logs for May 24th and May 25th, 2020, and claimed, it's a state document, claimed that the chlorine levels in the lazy river were at a certain chlorine level, he actually wasn't working those days. He had falsified the records.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
All right, we're back, RVA Trial Lawyers, and today we've got Kenny Berger. Kenny Berger's a friend out of South Carolina. He's got a really awesome practice there, and he's been doing really, really, really big things. So if you haven't heard, he got quite a large settlement. Was it last year, Kenny? The $26 million with Nick Rowley, the resort case?
Yeah, that was last year.
Awesome. Well, Kenny, we're glad to have you. If you wouldn't mind starting off by introducing yourself to our listeners.
Yeah. So my name's Kenny Berger from South Carolina. Moved around a good bit when I was coming through college, and took a year off before I went to law school because I wasn't sure if I wanted to go the PhD route or go the law school route, when I kind of had the thought of working for a bunch of years and ending up teaching 18 and 19-year-olds who had zero interest in what I had to say. That did not sound as appealing. I wanted something more tangible, more connected. So now we communicate with people of all ages who we just hope will listen to what we're saying. But I've been practicing in South Carolina, I guess about 16 years now, and just been very blessed.
That's awesome. My understanding, Kenny, is that you pretty much started your own firm right out of law school. Is that right? Or shortly thereafter?
Pretty close. Yeah, I worked for a great guy named Neil Laurie for 18 months. And I'd known Neil growing up, wonderful guy, really good practice, still a close friend, but just had it in my blood to want my own shop. My dad went to dental school when he was 18. He was planning on being a doctor, and then sophomore year of college, after he started at 16, had a chance to go to dental school. And so he did it. So by the time he was 25, he had a dental practice, 2 kids, and had been to Vietnam and back. And so when I was 28, I was like, man, my whole life is passing me by. I've accomplished nothing, which is obviously crazy, but that was just my perspective, or that was my point of comparison. And so I was in a hurry. And the beautiful part is this is into 2010, started 2011. And that was kind of the starting point of a huge amount of information being shared nationally through more webinars, through lots of additional seminars that supplemented and complemented AHA. There's just this proliferation of information, be it your trial guides, was really, heck, maybe it was already coming to its own, but seemed to be getting better and better. So I felt like I could start my own practice, and when I needed help or wanted help, it was available to me. But I didn't necessarily have to work under someone or for someone to gain the legal education I sought.
Now, did you start honing in on personal injury from the start, or did you have more of a general practice when you got going?
Yeah, so I had no idea what I wanted to do through law school. In fact, in law school, I didn't even know if I wanted to be a lawyer. And then when I worked for Neil, within the first couple weeks, he had a large segment of his practice was personal injury. And I very quickly learned that I enjoyed representing people who were truly hurt and needed help. And I did not want to represent folks that I wouldn't necessarily trust alone in my house for an hour.
Fair. Criminal,
but it was
right?
And here's the deal though. Like, one of the things I recognized was the insurance companies treated these people exactly the same way. They treated this beautiful kid who did nothing wrong. All he did was, reckless driver, hit him. He flipped a car, broke a leg. He couldn't run track anymore. And this kid was getting treated the exact same way as some folks who, should be viewed with some skepticism. I was like, well, that's BS. I just want to represent real people and real cases who are getting screwed over by insurance carriers. And that was the real push. And early on, probably 2/3 of the practice was personal injury and 1/3 was workers' comp. And I just wasn't that good at workers' comp. Other people understood the system better. You try those cases to a commissioner who's been appointed by a governor. It just, again, it didn't feel quite as real. It didn't feel quite as community connected. I went to public schools all the way through, and I've always found it easier to talk to the people it feels like I went to school with than, somebody who's been appointed by another person who's been appointed or elected.
No, that's awesome. And so it's interesting, you mentioned that in 2010, 2011, information about how to become a better trial lawyer started really spreading. I've got the same impression that during COVID kind of had something similar happen, right? Especially with all the stuff with what Dan Ambrose did with Trial Lawyers University. I mean, nowadays, I think the resources to some extent are overwhelming. I mean, there's an endless list of books, an endless amount of podcasts, right? And then there's tons of stuff. But the cool thing about what we do is a lot of trial lawyers genuinely are willing to help each other out, which is great. Is there any, I guess, starting out as a young lawyer in this practice area, was there any kind of school of thought that you followed? I know some people kind of grow up in the Reptile, the Keenan, and I'm sure there are, probably 5-10 other different methodologies.
Yeah, You make a great point on everything really getting kicked up to the next level with COVID, and Dan Ambrose and others are to thank for that. And I agree with you. If anything, the challenge now, it's almost there's too much information, and you really got to be careful to make sure that the information that you are digesting and applying is based on experience and not just advice. I think advice tends to hurt if it's not rooted in experience. So talk to people who've actually done it and been successful with it. And to your other question, so I started practicing in 2009, and I worked on some political campaigns through 2008, which was a cool time. Again, I didn't even know if I wanted to be a lawyer. And then right after the 2008 elections ended, I woke up the next day and was like, I should probably take the bar exam. I don't have a job anymore. But anyways, I say all that to say, I started in 2009, start my own shop 18 months later on January 3rd of 2011. And we're just one state over from Georgia. And so the first thing that I really latched onto was what Don Keenan and David Ball were teaching in the early days of the Reptile. And when Don and David were doing it together, I thought it was tremendous. I thought it was a perfect counterbalance and just really, really wonderful stuff, and taught me a heck of a lot about being a lawyer, taught me a lot about depositions and deposition prep, and has influenced a good bit of my thinking. And I think the biggest takeaway, if someone said, describe the Reptile in one word, I'd just say foreseeability. And if you just kind of focus in on foreseeability, then the Reptile is a wonderful, wonderful tool, the same way that there's so many other tools. And for me, I remember watching David Ball speak, and he talked about damages being the justification for jurors doing what they wanted to do to address the defendant's conduct. And that was kind of a light bulb moment for me of, okay, let's always make sure we tie the defendant's conduct to a different form of damage for our client. And then when I read Trial by Human by Nick Rowley, it took a lot of those same concepts and just augmented them. And I felt like, all right, if we can pair focusing in and really getting to a root cause analysis of why the defendants did what they did, knowing how dangerous and how harmful the outcomes may be, and then we really complement that and pair it with the human story, we should be able to make, do some great work. And that's really kind of the formula, if you will. It's not formulaic, but that's the 1-2 that we applied in this case with Nick that I know we're going to be talking about later, where a little boy got hurt real bad at a resort in South Carolina.
No, absolutely. You know what I've noticed, Kenny, is that I've been fortunate enough to go to a lot of the national conferences, and I always meet great people, learn a lot, but I have started seeing that methodology kind of being used by everybody, right? Like at least the people who are getting really good results for their clients. Defendant's conduct is oftentimes highlighted, and no surprise when we see those massive verdicts, right? Oftentimes it's because the defendant's conduct was just so atrocious. And then of course the damages are sufficient to sustain a large verdict. But it's, I didn't even know what personal injury was in law school, which is kind of crazy. My law school just said, hey, big corporate law firms, come talk, go to them, da, 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 da. Yeah, and there's a few people who do public service, and then, anyways. But it's, and I understand why, right? I mean, you want to be able to tell your prospective students, you come to our law school, there's a good chance we can get you into this type of job, making this amount of money. So it makes sense. I have found that personal injury has been so fun because it's like being a prosecutor, especially when you have those cases like what we're about to talk about now with your case and that you and Nick Rowley did. But like when you go after a bad actor, like a corporate bad actor, I mean, gosh, it is so much fun. And you are like on the offensive as a prosecutor, yet instead of putting somebody in jail, you get to hand someone a check, right? So it's a hell of a lot of fun. Well, let's get to that. So massive case in researching and preparing for this, Kenny, it's clear that you and your firm did a ton of work over the years getting this case ready. Would you mind sharing a little snippet about kind of what that case was before we start digging into it?
Yeah, absolutely. So this was Memorial Day of 2020 at a resort called Caribbean Resort and Villas down in Myrtle Beach, South Carolina, large resort. And they were part of a group initially that owned about, give or take, 10 or 15 different hotels along the coast in South Carolina. And their whole business was built, the entire business model was, let's have a ton of swimming pools to attract kids and really pitch swimming pools for kids because kids love swimming pools and that's where families want to go. And the kids can be in the pool and the family can have a great time. And let's just all spend a ton of money and have fun at the beach, which is all good and well. That's great. Like that does sound good. The problem that this resort ran into is they basically made a decision that the pools stay open no matter what. Come hell or over-chlorinated, dangerous water, poison water, the pools were going to stay open. And in our particular case, a little boy named Ashton Douglas, who was 3 at the time, was down there with his family, and he's in the lazy river for hour after hour after hour, and ends up sustaining severe chemical burns around his private area. It didn't damage his ability to reproduce. Hopefully he'll still get to be a daddy one day and be a great daddy, but it did leave permanent scarring around his private area and his pubic area. And it started out when the case first came in. And let me say this, Sharif. I mean, when this case first comes in, nobody thought, this is a $26 million case. That just wasn't, it wasn't at that point. It was, man, this little boy suffered and has these terrible burns. And our thing was like, why did this happen? If this is such a not supposed to happen,
right?
Doesn't really happen very often. So when it does, there's got to be probably a really bad reason and a bunch of really bad things that had to come together for it to occur. And that's exactly what we uncovered.
That is wild. No. And how did it get to you? Was it just an internet lead or something like that? Or
that's a great question. The little boy's mom wasn't even going to hire a lawyer, but his aunt, a woman named Selena Locklear, Selena started going on the internet, and we had some information on burn cases, and we had an office and have an office in Myrtle Beach. We're based in Columbia, which is right in the middle of the state, but have a statewide practice. South Carolina is not a real big state. You can have a statewide practice here without ever having to drive more than 2.5 hours if you're based in Columbia. But we opened a second office in Myrtle Beach, and she wanted someone with an office in Myrtle Beach who'd done burn cases before, which we had. And I went down there and offered to meet them. They lived just across the border in a place called Lumberton, North Carolina.
Yeah, I'm familiar. I used to be at Fort Bragg, which is, 30, 45 minutes north of Lumberton, I think.
Yeah, so Lumberton's a tough place. And the Lumbee Native American tribe had been overlooked and mistreated generationally. And this family, one of the challenges we ran into with this case was this family did not have, in some ways, the same outrage that like you or I would have. I mean, if someone burnt my child, I'd want to burn the resort to the ground. This family, one of the challenges we ran into, had very much a, well, shit happens and golly, life is hard kind of perspective. And in one way that made them incredibly strong and perseverant and low maintenance. But we also had to work with them as they got ready to testify at deposition or at trial to bring out their truth, not their truth in the sense of the way they'd always been treated, but what they thought the law should be and how they thought they should be treated. But they had come down from Lumberton. I offered to meet them up there. They said, no, we'd rather meet at your office in Myrtle Beach. We met there. And again, Sharif, when this case first came in, I was working on a couple other cases that really had my attention. There was an attorney at our firm who was handling the day in, day out aspects of it. And a couple months in, I went to a week-long workshop out in Montana, a trial by human workshop led by Nick Rowley and his firm. And out there met a wonderful instructor and lawyer by the name of Brian Ward. And Brian and I hit it off, became fast friends. I found him exceedingly bright. I mean, just brilliant guy. We got to talking about the case some. He took an interest in it, invited him to come on board. And so Brian deserves a lot of credit, and one of his team members, Aaron Powers, for doing a lot of work with us kind of in the buildup and during the discovery and trial prep stage of this case.
And where does he practice? Is he out of South Carolina as well, or is he a part of the Trial Lawyers for Justice group?
He's part of the Trial Lawyers for Justice group in California.
Okay.
And something that we're getting ready to share more broadly in the very near future is after our work on this case, Nick was kind enough to basically share with us, hey, this is one of the best workups that I've seen. Do you want to be our TL4J partner in South Carolina? And I was like, well, hell yeah.
That's awesome.
Thanks, man. Awesome. So that's something that we're going to be
that is awesome.
Sharing more broadly. But yeah, so Brian's out in California. We were in South Carolina. We ran the ground game by and large, in a really pivotal moment in the case. And I think this is a really important thing that I've learned is the magic that happens in a case, at trial especially, is a lot of times built on these seemingly mundane efforts to get discovery, right, to take depositions, to request more discovery based on those depositions, to request more depositions based on that discovery. This kind of osmotic relationship between written discovery and depositions, kind of doing the doing. And the more evidence you can develop, the more work you put in, to quote Zoe Littlepage, the more magical it becomes. The work becomes magic, And in this case, what we got were these very ordinary, seemingly innocuous pool records that just talked about chlorine levels. And I was looking at them. I mean, again, for all intent, nothing flashy. This ain't exciting, but looking through these chlorine levels, I'm looking at them like, man, the records are too perfect. Like, they're just too perfect. And I start looking at this one section in particular, and it's the same initial as an R 6 days in a row. And I thought, maybe the guy worked 6 days in a row, but maybe he didn't. let's request his timesheets and see if he actually worked all those days. We requested the timesheets, and sure enough, the 2 days that our little boy was in the pool, this guy was off. His name was Juan Rivera, and even though he'd initialed the pool chemical logs for May 24th and May 25th, 2020, and claimed, it's a state document, claimed that the chlorine levels in the lazy river were at a certain chlorine level, he actually wasn't working those days. He had falsified the records. And so we get him to a deposition, and about 2.5 hours in, after he'd given us a lot of the other stuff that we wanted, we confront him with these logs, and he ultimately admits that, yeah, he falsified them. And then Erin Powers, to her credit, again, a member of Brian Ward's team, had the wonderful idea. She said, ask him how long you've been doing it. And I said, Mr. Rivera, how long have you been falsifying these records before little Ashton Douglas ever got in y'all's pool? And he said, he'd been doing it a year. And then I had the good sense to be like, well, Mr. Rivera, when did you stop? And his answer was he didn't stop until he found out about his deposition, which was 3.5 years after he started. So he did it for a year, burnt a little boy, and kept doing it for another 2.5 years. And what gets even crazier is that even after the resort found out about it, they still didn't fire him for like another month until we sent a request to admit, asking if he was still an employee there.
That is wild. What was his incentive to falsify?
His quote was, he just did it for, there's a state agency called the Department of Health and Environmental Control. The acronym is DHEC. He just said he did it for DHEC to keep the pools open.
Were you able to work up the chain at all? I mean, was there anyone above him who, I guess, knew or were a part of this?
Yeah, so, you're a very good lawyer, which means you ask very good questions. The answer is yes. So what we did is designed a plan where we systematically went up one piece at a time, one link in the chain, or one rung on the ladder at a time. So first we went to his supervisor and got some great testimony from his supervisor, who, when asked if he wanted to know how long Mr. Rivera had been falsifying the records, answered, quote, "I don't really care." We then went another rung up the ladder to their department supervisor. And when we started asking him questions about the pool chemical logs, he started pleading the Fifth Amendment. I think there's an important practice tip here in that he didn't actually plead the Fifth Amendment. His lawyer instructed him to plead the Fifth Amendment and kind of sort of asserted the Fifth Amendment on his behalf, which is like no, you can't do that. But who cares? Like,
oh, it's beautiful.
Dude,
yeah.
Who cares?
Right.
So all I'd say is, Tony, are you in fact asserting your Fifth Amendment right against self-incrimination? Answer, yes. And so and his name's Tony Robinette. So we just went through all that with him. One of the reasons that the supervisor of the whole department was so afraid and was pleading the Fifth Amendment is on Rivera. You can't threaten criminal action in a civil case, right? But you can report it. So we reported what was going on at the resort to DHEC's enforcement wing, and they ended up arresting him. So by the time Robinette testified, he knew that Rivera had gotten arrested, and he was like, man, the hell with getting arrested. So anything he thought might implicate him, he just pled the Fifth Amendment, which, again, just doesn't happen every day. We then went up above him. They had a 30B6 witness who lied about some shit, including prior reports of burns or problems with pools. And then we went up another rung to the general manager over the whole resort, who testified, quote, "Pools are our moneymaker." And we just kind of kept going up. And the higher we got, the worse it got for them.
What was the defense saying this entire time? I mean, and another question I have is, what were their defenses?
Yeah, I guess two main things. One argument was worse than the other one. The one that really I didn't think was very effective was they were like, well, you can't even prove your case because you don't even know what the chemical levels, what the chlorine levels were at the time Ashton was in the pool. There was no real testing done by DHEC until 48 hours later. And well, when DHEC tested 48 hours later, the chlorine levels were literally off the chart. But the resort's defense was the only evidence there is of the chlorine levels on the day Ashton was in the pool are what Juan Rivera put in the logs. And we're like, yeah, exactly. The falsified, manufactured, illegal documentation when y'all violated every duty you had to test, monitor, and document. You can't blatantly and willfully violate state law and then try to benefit from it under the law. That's insane. So that wasn't a very good defense. But the other one that I thought, that we did have to deal with, right, was that Ashton was the only person who got burnt, and that if it was really that bad, other people would have gotten burnt and Ashton would have had burns on other parts of his body. So how did we deal with that? First things first, they couldn't actually tell us other people didn't get burnt. All they could say was they didn't have records of other people getting burnt. And we already knew what their records were. Another thing we did is we went on Google, and there's a way, they have like over 3,000 Google reviews. So we didn't sift through all 3,000. There was actually a search bar within the Google reviews where we just searched the words chlorine, burn, injury, things of that nature. And so we found some Google reviewers who had reported burns or issues with chlorine to the resort before Ashton got hurt. And we just showed that the resort didn't have any documentation of those people either. So the idea that we should trust the resort and trust the documentation about no one else being burned when we've already proved that's demonstrably false through Ashton and the lack of documentation they had on him, plus these prior reporters that they denied, was one way we dealt with it. And then with Ashton, where he got burnt, we had kind of like you've done in your cases where, I didn't know anything about chlorine. Not really. I knew about burns and burn injuries and debridements and infection and things in a sense from doing thermal burn cases. Or thermal injury to the airway and god awful cases where someone died, like still alive when the fire occurred. But we hadn't done a true chlorine burn case. We had to learn a ton about chlorine and a ton about how these burns happen in pools. And so what we learned was little kids and older people literally have the thinnest skin, so they're the ones who are most susceptible to chemical burns because the chlorine eats through the skin. It oxidizes, it burns through. And it's typically the area that your bathing suit covers, where your skin is thinnest, kind of the thinnest of the thin, around your private area, because the chlorine gets trapped there for longer and you have more sustained contact with the chemical agent, even after you get out of the pool. All that combined with the fact that these burns a lot of times are based on duration and concentration. Ashton was in this lazy river longer than certainly any of his family members. Some of his family members had fading bathing suits. They had jewelry that had been damaged. They talked about their eyes burning. Nothing that really set off alarm bells at the time, but in retrospect, they could kind of look and say, there was something going on with the chlorine. But Ashton was just in it the longest. And we also believe that Ashton got burnt the worst because, in essence, they bombed the pool while he was in it. And the lazy river, again, when DHEC came out and finally did a valid test, the lazy river was the one with the chlorine levels literally off the charts. You can't, these test monitors only go up to 10. The stuff was over 10, it's going to burn you.
What prompted DHEC to come out and monitor? Was a complaint made?
Yeah. So Aunt Selena is kind of the hero of the story. She's the take charge member of the family. Heather Douglas, Ashton's mom, is a remarkable, remarkable woman. She's a nurse up there. And then Aunt Selena was the one who was sounding the alarm bells. She was the one who said, hey, we need to get a lawyer involved. She's also the one who reached out to another family member who was a firefighter and asked what to do because Ashton had gotten burnt. And the firefighter family member said, hey, get in touch with the local fire department, which Selena did. Local fire directed her to DHEC. She reported to DHEC. And again, DHEC was there within 48 hours.
Got it. Once you guys found the lie, I mean, that must have been huge, right? I mean, because did defense counsel start trying to resolve the case at that point? What happened?
Yeah, so early on in this case, before we knew anything, defense counsel had the opportunity to settle the case. After we figured out the lie, we busted that on, I think this was December 16th of 22. It was a Friday, whatever that Friday was, is when we busted Rivera. Brian very quickly put together a draft for Nick to look at. Nick sends out the letter that Monday, December 19th, that says, look, I mean, you're just toast. I mean, you've got a multi-year cover-up, you've got fraud, you got conspiracy, you got all these things going on, and look what you did to this child. And there was a video of Ashton. You might have seen the Sharif. There was this video of Ashton that's just horrific, where he's in the hospital and it's after a debridement, and he's banging himself in the head. And the reason he's hitting himself in the head is he's trying to distract himself from the terrible pain from the debridement. It's torturing a child. But we included all these things. We sent it all off to him. And at the time, we thought they had $11 million in coverage. So we gave them the opportunity to settle the claim for $11 million, provided they could prove that was all the insurance they had. They offered us $400,000, and ended up changing attorneys shortly thereafter. And the next attorney is the one who, to her credit, helped uncover a third layer of coverage for another 15 that provided a total of 26, and which we then said, well, in that case, you'll need to pay 26.
So in response to that letter, it was 400,000. That's crazy.
Yeah, we thought so.
Wow. That is wild. And so then that attorney ultimately moved on. They brought in someone else. And did the next defense attorney look at it and said, yikes, this is a real case, and work to resolve it at that point? Or is it still a fight?
Man, this thing got fought tooth and nail. Tooth and nail on negligence, tooth and nail on the extent of injury and damages, tooth and nail, especially on causation. They hired this quote, forensic toxicologist, and I'm going to paraphrase, but his report said in essence, there is no one to blame for the injury to the toddler but the toddler himself. For the toddler, though unknown or unbeknownst or some big word, to the toddler, it was his urinating in a diaper that, when combined with chlorine, created chloramine that produced the injury to him. And it was like, hold on. They spent money, and we were in federal court. I mean, in state court at the time, you had to produce materials that were shared with defense counsel. Now the rule in South Carolina, state court rule has changed to mirror the federal rule. But even at this time, I mean, this is a federal court case where they had the opportunity to work on drafts. And it was like, man, the final draft of this report that includes a section that blames the 3-year-old for peeing in a pool. I mean, if permanent chemical burns around your genitalia and permanent scarring, it's going to have a huge impact on you, especially when you get to middle school and high school and that part of your life. If that's now the penalty for peeing in a pool, God forbid any of our kids ever get in one again.
It's wild. It's wild. So what led to it to resolve? Like, how close were you guys to trial? What was it that finally got them to give you guys the full limits?
Yeah, I mean, the plan was to try the case. I mean, we didn't ever think the case was going to settle. Like, that just wasn't, settlement just wasn't, I mean, they offered 400. Then I think at some point they offered the first layer of coverage $1 million. But the whole deal on our side was either they pay 26 or the case gets tried. And we didn't think they were ever going to pay 26. Now, we thought we were going to get a verdict for more than 26. But we didn't think they were going to voluntarily pay it. And coming up on the end of 2023, we put together a fantastic video. A guy named Nick Vieser, who does a great job. Nick Vieser helped put together a video in which, myself and Brian and Nick and some family members, along with different footage from depositions and so forth, just put together a wonderful video. And we sent that video along with some other materials and just said, look, this is your last shot. Here's a chance to settle all claims for $26 million by the end of the year. And the third layer of coverage reached out and said, hey, can we have until, I think it was January 19th, in light of the holidays. And the request was reasonable. And Nick said, yeah, y'all can have until January 19th. That's reasonable. And then the lawyer for the primary and secondary layer of coverage reached out and said, hey, we need until the end of the day for this February mediation. The case was set in April. But we want until the end of the day at mediation. And we just all said, hell no. Like, I think Brian maybe had the best line on that. He was like, look, y'all have had this case for years. There's nothing else that y'all need to know beyond everything that's already apparent. And Nick said, look, if y'all don't pay it by January 19th, the only thing that we're going to do at mediation is negotiate above your policy limits, and you're going to have to decide how much more to pay. We think this is a $100 million case. And I'll tell you one thing that happened along the way in this case is we had our first child, my wife and I did. And that made me, I think, a better advocate for a child because I had the golden rule myself in a very tangible way. And when I'd see my child, like we'd be bathing our baby, and then I'd think about Ashton, and there was no difference other than, Ashton was in water that caused him permanent harm through corporate fraud, and our child was safe because we took time to make sure she was. And when I started thinking, if you burned my child, and I started thinking if it was a little girl, not just a little boy, but a little girl, 50 million, not nearly enough. 100 million starts sounding more reasonable. 250 million, maybe. And something that we said is, look, if they're allowed to pay $1 million or 5 million or even 10 million, they forget about this. They might forget about it in 5 years. They might forget in a decade, but at some point they forget about this. At $100 million, the company never forgets. A number less than that, within a generation, they forget the name Ashton Douglas and they forget the child or anyone they ever harmed. And so we really kind of rallied around, $100 million, and that was the number. And all of a sudden we started kind of thinking, yeah, they'd be insane not to pay 26. And a minute before the deadline, we got an email from the adjuster, I believe is an attorney for the third layer of coverage, accepting our settlement offer and tendering the 26.
How did the workflow go with, it sounds like you guys had a pretty decent sized team on this case. How many lawyers were involved? How did you kind of make sure everyone was on the same page? And I'm asking for selfish reasons. I mean, I love co-counseling. Our firm just got hired for a case against Ford in Texas. It's going to trial in April. And one of our struggles right now is, all right, well, who's doing what? How do we figure this out? How do we keep all our information together in an organized manner? So I'd love to learn how you guys did that.
A couple ways. I'm not saying that this is the best way, but it worked for us. We had a couple lawyers at my firm, Brian and Aaron, and then Nick calling shots. And what we did is we get on sometimes it was weekly, sometimes it was monthly, somewhere in between weekly and monthly Zoom calls. And we go over what I think is a really simple thing was, all right, who does what by when?
Right.
And making damn sure and creating accountability, right? Like if I say I'm going to do something, it's one thing. If I tell Sharif and a team I'm going to do it, like the likelihood of me doing it skyrockets.
Yeah. Now you're I'm up till midnight making sure that thing's done, right? So yeah.
Oh man, I want to do a great job for you. Not that I don't want to do a great job for myself and my client. You know what I mean? There's another layer of
accountability. Yeah.
Yeah. And as I push you, you push me. and we keep pushing each other to do better and better and better and better and better, but work. It almost becomes like competitive in a sense, but like in the most positive sense, like, I want to do my absolute best for you. You want to do your absolute best for me. And so we get on these calls and we decide, okay, who's going to do what by when, why, and we just have an honest exchange of ideas. Like there was nobody who always had the right answer, and there was nobody who didn't contribute in a really substantial way. I mean, again, I think like in these calls, Brian and I would do a lot of the talking, and then Aaron Powers would be like the brilliant, observer, editor, who'd say, guys, why don't we, and she'd just say something really simple. And Brian was like, oh yeah, let's do that. And that was really how it went. We just kind of made decisions on who we thought made the most sense for different depositions, the sequencing and timing of things. And then again, Nick was the ultimate decision maker, and everyone was good with that, right? Like there was a chain of command, single points of accountability, clear decision maker, and everybody was on board with it. And for me, it's like I run my own shop. We've done well for ourselves, all that kind of stuff. We've gotten good results over the years. But man, when you're working with like best of the best of the best, it's like, hey, you tell me what to do, and
right.
Right. Barring family emergency or my own health, man, it's going to get done. And I think that was a great experience for everybody on the team, really, really pushing each other higher and higher.
What are some of the main things that you learned working with that group?
I think for me is if you hit gold or you find something great, keep going. I know for me, I've had a tendency, maybe once I find something great to be proud or be like impressed, and not to continue thinking like once you get a good answer, we prepare so much for like bad answer, difficult witness, whatever it may be, but to really be prepared for a good answer or a good piece of evidence, and then how to use that as a bridge to even better evidence, to even more powerful points in the story. And again, to bring it all back home to how they knew this had a high probability. A child was going to get hurt at some point. They didn't know who it was going to be or when it was going to happen, but they knew, and they chose to do it anyways. And then why? Why would they do that?
It's money, right? I mean, that's a lot of these cases, I think, always come down to, profit over people, right? Profit over safety. And it's a pretty simple theme that unfortunately we see over and over and over again.
You got it.
It is really amazing. I spent probably the first 6-7 years as a lawyer. I'm going on year 11 now, but doing criminal work. And people do some wild things in criminal cases, right? But I have, doing the personal injury work and kind of seeing the arguments that people will, even in your standard car wreck case, like that people will make just to save money is incredible. Any young PI lawyer listening to this, like you get your car wreck case, the other side hires, and they end up having hip surgery. The other side hires a doctor, say, yeah, it should have resolved within 6 weeks. Everything else is just degenerative, right? And so then you just come back and you say, oh, so my client was 45 years old. Had nothing, her hip surgery was just because she was 45, right? Nothing to do with the car wreck. But it's amazing to me that how much money will drive the insurance companies and the defense attorneys to really bring up any argument they can, and to put real money behind it, right? They're not just throwing it at the wall. Like they're spending thousands and thousands of dollars to make these arguments. And it's wild to me sitting here, listening to you talk about this case and having done some research on it and seen the pictures, seen some of the videos, and like, how do you not look at that and think this is a big deal, right? And, but it keeps happening. It's job security for us, right?
When that was, that's what the treating burn doctor said at one point in his deposition. He was like, have you seen the photos? These are really bad. I think he was getting genuinely upset that, the insurance industry and their hired attorneys we're trying to downplay what happened to this child. I mean, to an ordinary person or to a medical person, I mean, it's outrageous.
Did you all, I found working on cases that I can sometimes, I'm sure this happens to all of us, get caught in the weeds and get really upset or concerned about maybe an issue that probably in the grand scheme of things isn't that big of an issue when you take a look at the whole case. Did you all at any point focus group or run data studies so you, in some respects, just have the confidence to know, hey, this case isn't just valuable because of what I think, but it's valuable based on all these other studies that we ran?
Yeah, we ran a couple focus groups, one more valuable than the other. There's a guy in South Carolina named Derek who does a really good job with focus groups, and I thought they did a wonderful job in a local focus group. And one of the things that we were able to identify or ascertain is there were certain jurors. There was kind of a juror profile, and something that hadn't resonated with me until the focus groups was just really women of color. They looked at this and they were like, yep, of course this happened. And of course that's what they're saying about this little boy. And our little boy, Ashton, is like a lot of folks from Lumberton, part Lumbee Indian, part African-American, part Caucasian, part. I mean, just, a child of really the world in a really beautiful way. And so, they could immediately identify our worst jurors were young white males without children who blamed mom. There were certain jurors who didn't have kids, who thought somehow mom should have done more. Like mom shouldn't have allowed him to be in the lazy river as long. Mom shouldn't have allowed him to wear the same bathing suit the whole time he was swimming. After he got out of the pool, not only should mom, what mom did, she gets rid of the bathing suit, dries them off, uses baby wipes, does more than like most parents would do. Very conscientious person, again, a nurse practitioner, dry clothes, the whole deal. But you had certain people who wanted to point the finger at mom and also had a tough time believing that this pool could have hurt this child so bad, which one of the things that drove us to do, and our expert in the case, our pool expert in the case, a guy named Tom Griffiths, reminded us of just how dangerous chlorine is. And our forensic toxicologist talked about, remember, anything can become a poison in a high enough dose. But if you go back to like chemical warfare in World War I, chlorine was the first type of chemical warfare in World War I. Chlorine is like super duper dangerous if, administered in high enough dose.
Did you guys look at the concentration levels? I'm just curious now, like the chemical war weapon, right, with chlorine, how did that compare to the levels in that pool?
It's different. So chemical, like chlorine in gas form is more dangerous, but if you take enough chlorine and put enough of it on the skin, ultimately it's going to burn through a child. And what we knew for certain was the chlorine levels were so high and so illegally high that they caused this type of injury. This type of injury doesn't happen without chlorine levels being off the charts. And unless chlorine levels are off the charts, this type of injury does not occur, which is a little bit circular, but people seem to be able to really understand that, like, you can't get hurt this bad if it's just a little bit of chlorine. And more than anything, where all the jurors, not all the jurors, the vast majority of jurors latched onto, and one of those kind of quote Mark Mandel, something they just couldn't get over was the fact that the corporation, this really large resort, had falsified the logs, didn't care, pled the Fifth Amendment, and hadn't seemed to learn their lesson.
Sounds like quite a battle, but you guys did great work.
Thanks. One other thing, going back to follow the money, one thing we were able to uncover, and this helped get the case resolved too, we ultimately were able to show that the parent company of this resort was called Britain Resorts, but that Britain had sold out to a company called EOS Investors or EOS Hospitality up on Madison Avenue. So what we showed was that this wasn't a local company. This wasn't just a Myrtle Beach resort. This was New York. And if you follow the money far enough, it goes exactly where you think it would, which is to downtown Manhattan. And look at what they were doing in the name of $1 to a 3-year-old child here in the Carolinas.
That is wild. Yeah. Yeah. Gosh, that would have been a hell of a case to try, though. So it would have been, one of my, I think it's an illusion, right? But you follow guys like Nick Rowley and them, you think, or at least I have thought, like they just show up and magic happens. But I think it's very clear, having kind of followed him and some of the other big ones, the real magic happens in the preparation and in the work. And it sounds like during this case, Nick didn't show up at the end, write a letter, sign his name, and say, "Here you go," right? You guys work like crazy to get this thing done.
Man, everybody played their part, right? Like, man, we don't get paid that kind of money voluntarily without Nick Rowley. Like, Nick calling shots, hugely helpful. Brian and Aaron playing the enormous role they played, me and my team playing the enormous role we played. It was such an awesome team effort in this relentless pursuit of trial. And another great lesson here is, trial was option A, B, and C. Like, there wasn't really any thought of settlement. And one of the things that I think came across in an undeniable way to the other side was like, these guys are going to try the case if we don't pay them all of it. And so they paid all of it.
That's awesome. That's awesome. We've actually, at our firm, we've started not doing mediations because we find them to be more often than not a tool of the defense. And really what we're trying to do is have a reputation that we're willing to go to court. If we lose, that's fine. We'll get the next one. Right. And we'll see. I think it's starting to work, but I think there's really something to be said for having that fearlessness of saying there are no options. Here's your number. Here's the number. You can take it, or we'll see you in court.
Yeah, and so we're a mandatory mediation state, but it doesn't change that approach, right? At some point, it's hey, insurance people, you got two options. If you want to settle the case, this is what it's going to take. If you don't want to pay that, then you've got a jury trial. That's it. So let us know what you want to do.
Yeah, and it makes it simple,
super simple,
right?
Super fair, not personal.
No, that's it. No, it's great. Well, let's talk about the trial. Do you have a favorite part, or do you think there's a certain part that's most effective, or that you put most of your time in when preparing for trial?
I like opening. And part of the reason is, so here we're one of the last states to not, as a matter of right, have substantial attorney participation voir dire. It's at the judge's discretion. And what the custom has been here for a really long time is to have very minimal attorney participation. That's starting to change, thank God. But so what that means is opening is really the first chance you have to talk with and connect to these people. And it's just fun. It's like, for me, it's like you practice and you practice and you practice. It's almost like the Olympics, right? It's like you work on something for maybe 4 years, hopefully not that long, but heck, it might be 4 years you've worked on something like you would for the Olympics. And then you finally, the gun finally goes off and you get to start the race. So like for me, there's just like so much like anticipation. And it's just fun. One thing I'll say, I can't remember where I learned this first, but they were like, look, the time to pat yourself on the back is not after you give your opening, but after the defense gives their opening to see if it stood up. And something I learned from Nick and other people was on your first witness in order of proof, the witness who can best crush all the bullshit the defense just said in their opening. So that's an approach we've taken.
I like it. Trial by human, worth it?
Yeah. I encourage everybody to go. And to put it out there, we're planning on a 1 day in Charleston, South Carolina on September 26th. I think that date's going to hold. Jacob Norman is the man when it comes to to all things operations within the trial by human and TL4J world. But that's the current plan, and there should be some other dates that Jacob and his team announce soon. Yeah, and if you can go to Montana for a week, yeah, go. Like, it's beautiful, it's fun, you'll be a better lawyer. It's just a great way to spend a week. I mean, life's short, you know.
Yeah, no, it'd be great. It'd be great. I did the 3-week Spence College or Jerry Spence method. What was it? Was it last year, a year or 2 years ago? So, and we have 2 little ones, so I'm kind of on a short leash right now. But I do intend to. I want to go to a trial by human event.
And I say one thing. I think the plan right now is hopefully, depending on kind of what the schedule is, if they do a trial by human for a week out in Montana, it's super family friendly. But if we go this year, kind of schedule things work out, you know, my wife and our little girl, who'd be 2 and some change at that point, would all go together. It's super family friendly. Big Sky's a great town. It's wonderful.
That's awesome. Okay, well, that's something to consider. That would be great, because I think oftentimes, and I'm lucky to have an amazing wife, but I do feel guilty when I'm flying around the country going and doing all this stuff, and back at home, same old. So it'd be awesome to be able to bring them with. Gosh. Well, Kenny, this has been fun. This is a hell of a case you guys had, and it's really cool to have seen you go from starting your own shop to now. It sounds like teaming up with Nick and his team, which is really, really, really cool. So congrats to you.
Hey man, congrats to you and your team. You're doing big things. I think we talked, I can't remember how long ago. I think when you were first looking at either maybe some website stuff or trial practice stuff, combination of the two. And, you know, I've followed your career, and I'm always like, whenever I can love, whatever it is on social media stuff, I'm just really proud of all your success.
Well, thank you. I feel like we're a part of kind of this nationwide community of trial lawyers who I think are trying to do good work for the right reasons, and it's really cool. And I notice it. Like when I go to these events, I see the same people, and it's really fun. Very blessed to found this practice area.
Absolutely.
Well, Kenny, this has been a lot of fun. Thank you so much. I'm sure we'll stay in touch, and I hope I'm going to put September 26th on my calendar. So I'd love to come down to Charleston.
A lot of fun.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.